This podcast is sponsored by Quartz IP. For more than 20 years, the PracticeLink IP operations platform has helped some of the largest IP practices in the U.S. simplify and scale high-volume IP operations. PracticeLink is designed by IP teams for IP teams, bringing smart automation to mail intake, calendar management, and client communication while making sure service to your clients still feels personal. Learn how Quartz IP drives excellence in IP operations at quartzip.com.
Hello, everyone. Welcome to IPWatchdog Unleashed, where each week we journey into the world of intellectual property to discuss the laws, news, policy, and politics of innovation, technology, and creativity. With analysis and commentary from industry thought leaders and newsmakers from around the world, IPWatchdog Unleashed is hosted by world-renowned patent attorney and the founder of IPWatchdog.com, Quinn, who has twice been named one of the most influential people in the intellectual property community and recognized numerous times as one of the top IP strategists in the world. Take it away, Gene.
Thanks, Renee, and welcome everyone to this week's edition of IPWatchdog Unleashed. This week, I'm speaking with Kristen Osenga, and Kristen is a professor of law and associate dean for academic affairs at the University of Richmond School of Law. She teaches in the areas of patent law, antitrust, legislation, and regulation, and many of you in the audience no doubt know her. She's been a fixture at events and including our own events over the years, talking about things such as standard essential patents, patents in general, the interplay with competition policy and antitrust issues. And she's been on our webinars before. She's written before. She's everywhere. Kristen, it's great to have you join us here today.
Thanks, Gene. That's quite an introduction.
Well, it's all true. It's all true. You've done a lot with your career. You've done a lot of things that I think a lot of patent owners and innovators really appreciate, which makes you, to some extent, a unicorn in the university world, which we could address that a little bit. But before we get too deep, let's start at the very beginning and give the listeners an opportunity to get to know you a little bit better. How did you get into intellectual property in the first place?
I started out in engineering school, as a lot of patent attorneys do. I will tell you, when I was in high school, the thing that I wanted to do most was build artificial legs. I thought that would be super cool. So I went to undergrad aimed at biomedical engineering. Turns out I'm really, really bad at mechanics. So building artificial legs went out the window, and I moved more into the electrical space of engineering. And so my senior project was building a pacemaker, which was never put in a person, just to be perfectly clear, because that would be scary. So I came through undergrad, and I had some interesting experiences in undergrad that made me want to be an engineering professor. So I went to grad school for engineering after getting my biomedical engineering degree, and because it turns out I'm not good at mechanics, I went to grad school for electrical engineering. And while I was there, I was working with my thesis advisor, and it turns out electrical engineering professors are really boring. He basically supervised a lab and let his TAs teach his classes, and I'm like, well, I guess I don't want to be an engineering professor anymore. So at about that time, I went to a Society of Women Engineers conference, and there was a panel called What to Be If You Don't Want to Be an Engineer Anymore. And there was a guy on the panel who was a patent attorney. And I'm like, oh, that sounds so cool. You have your engineering background, but you get to do fun things and deal with people and talk and write. That sounds super interesting. So I went home and I started applying to law school. And I knew from the minute I walked in the door of law school, I wanted to be a patent attorney. Stayed that way all the way through law school and came out the other side.
That's great. I think a lot of people will resonate with that experience, kind of getting into engineering. I know I did get into engineering and then realize, well, I'm not going to be the world's greatest engineer by any stretch of the imagination, but I didn't want to give up on technology. So a lot of us are in that boat, I think. I see that when you graduated law school, you did practice for a while, unlike a lot of academics who just go straight into being an academic. You went to probably the biggest boutique in the IP world. You were at Finnegan for a while. What was that like?
It was awesome. I loved my time at Finnegan. I started doing patent prosecution. and learned a lot through that process. I got to meet engineers and work with some clients, in preparing patent applications. Really enjoyed that. And then I moved into doing some of the litigation, obviously as a second year associate, mostly reviewing documents, but it was just really exciting, really high paced. But it gave me a real respect, I think, for patent owners. And I think that, as you alluded to, that's something that sometimes my colleagues in academia may have missed in never getting the opportunity to work with clients on things that mattered. If you go straight from law school into academia, sometimes I think you miss a step.
I would agree with that. And I also think increasingly there's a lot of judges that miss that step as well. They don't really understand how their rulings are going to impact real people. But you also had an opportunity, and this came after your time at Finnegan, I think, right? To clerk for Judge Linn, who is just at the top of our industry. You look at many of the judges on the federal circuit over the years have been prominent patent attorneys. I'm not sure anybody had as prominent a pre-career as Judge Linn. He was really one of us. How did that affect you, influence you, getting to meet him and then work with him elbow to elbow for the time that you were a clerk there?
Working for Judge Lynn was the best experience. I oftentimes tell people that I work for the best federal circuit judge, and some of my co-clerks that clerk for other judges will fight me on that, but I really truly think I work for the very best judge because he cares about patents. Judge Lynn also cared about clerks, and so the two of those together was really special, that he would talk through really important issues about patent law with his clerks and really try to dig in, and he would bring in his patent work experience, and he hired clerks that often had patent work experience. And so they were really deep, detailed conversations, really aiming at getting patent law right. And I couldn't ask for a better way to really deepen my understanding of patent law because he's just so smart. He's just so smart, and I'm so lucky that I worked with Judge Lynn.
I don't know him nearly as well as you do, but I've gotten to meet him a few times, and he's just an incredibly impressive guy. And I think the patent system would be in a much better place if he decided not to take senior status. Now, that's not a jibe at him in any way. The older I get, the more I am looking forward to retirement myself to do all the things I don't have time to do right now. So I get wanting to take a step back, but boy, the patent system could really use him in a full-time capacity.
That's for sure. That's for sure. And he's still sharp as a tack. I've gotten the chance over the last few years to talk to him during the Naples roundtable conventions down in Florida every year, and he's still thinking about patent law quite seriously.
Yeah, absolutely. So now let's pivot just a little bit. And before we get into the substance of what your scholarship is, where your focus is at the moment, how did you get into academia? How did you go from, okay, you were at Finnegan for a few years, then you went and clerked for Judge Lynn, and now all of a sudden you become this brand new at the time academic pursuing a patent and competition trajectory?
So the competition part came later. I'll get there, but I went to law school and I had a patent professor and I was working as his research assistant or doing an independent study. I don't know. I was spending a lot of time talking to my patent professor, and he asked the question you asked at the top of our discussion. How did you get into engineering and how did you get into law? And I explained the whole situation to him that I wanted to be an engineer, but then I didn't want to be. But I had gone to grad school in engineering because I wanted to be an engineering professor. And he's like, well, why do you want to be a professor? I'm like, well, I really like teaching. I really like talking. My parents have been family has been teachers. My mom's a teacher, my aunt, my uncle, everybody's a teacher in my family. I don't want to teach kids, but I really would love to teach. I have the soul of a teacher. So I'm telling my patent professor this, and he's like, why don't you be a law professor? And I'm like, huh, never even dawned on me. I'm the first person in my family to go to law school. I certainly wasn't thinking about anything other than being a lawyer. That's why I was in law school. And so he kind of opened the doors in my mind to maybe I would be a good law professor. And so that happened while I was in law school. And what he told me is like, here's what you need to do. You need to work for a really good firm. You need to clerk for a really good judge, and you need to publish your student note. And those are kind of the feathers in your cap that are going to get you into academia. And I did all those things. So Finnegan's a really good firm, and I clerked for Judge Lynn, a really good judge, and I managed to publish my student note, which, because I was on the Elder Law Journal, had nothing to do with patent law, but it was about technology. I actually published a student note about telemedicine because when you get on the Elder Law Journal, what else can you do with yourself? There's no patent law involved. um, so I did those things, and then as I was coming off my clerkship with Judge Linn, I was trying to decide, should I go into academia or should I just go back to Finnegan, because the door was open there and I loved it and I loved being a patent attorney, and I thought about it for long and hard for a while, but decided I would throw my hat in. I had a brand new baby at the time, and I thought, well, law firm life and a brand new baby, not ideal. So I threw my hat in and I got first a visiting job at Chicago Kent and got to work with some fabulous IP professors there while I learned the craft. And then I've been at Richmond since 2006, actually. So I've been 20 years now in my current home of academia.
So, and you started teaching at Chicago Kent, and I know a little bit about that. I was a law professor for a number of years before, so I think I know how your first job comes about. Maybe that's how many first jobs come about. But that was just an opportunity that was presented to you, and you took it.
I applied. There was a program at Chicago Kent, which I don't know if it still exists because 20 years have gone by. But if you would go and teach legal writing for them for a year or two, they would also let you teach another class. So I went and I taught legal writing and patent litigation at Chicago Kent for a couple of years, and it was pretty awesome.
That's great because a lot of law schools, I know, once you're on the legal writing track, moving over to the substantive side is at various levels of impossible.
Yeah, they had a program set up where they really, for at least a few of their legal writing faculty, the point was to push us up into academia. It was a kind of a more like a fellowship program to give you time to write away from being in a firm. So theirs was intentionally set up to send us out.
That sounds like it's very thoughtful and a good program. I wish more law schools would do that. So then you wind up with Richmond. So what was the draw to come to Richmond and then maybe stay in Richmond? Not to say anything bad about Richmond. I live in Virginia as well. It's a different part of the state, but why Richmond?
I was very successful on the teaching market, so I had a lot of opportunities, but the best ranked school at the time that offered me a position was Richmond. And when we came to visit, I liked the city. It seemed like a very livable place. I had an offer from a school in New York City, and I'm not a New Yorker, so that wasn't going to work for me. I grew up in the Midwest, and so Florida wasn't going to work for me. And so Richmond really offered, a great place to live, to raise kids, and a school that was very good. It's moved around in the rankings, and again, what do law school rankings actually matter anyway? But when you're in academia, they kind of matter because occasionally your opportunities to publish are tied to the letterhead on your article. So Richmond being a pretty good school with a strong commitment to both scholarship and teaching, it really fit with me. And I've stayed for that very same reason, that they both value teaching and scholarship. And they kind of let me do my own thing when it comes to scholarship, which has been really kind of nice.
Yeah, that's the thing that's always interests me about law faculty. Is in the scientific world, often things are peer reviewed and secret. You don't know who submitted this article that you're reviewing for consideration for publication. You know, maybe a little bit about their credentials. But in the legal world, in the law professor world, you lead with your resume and with the title on the letterhead and the university behind you. And that does matter, I think, way more sometimes than the content of the article, which I think is unfortunate because there's a lot of really good people at places that are not. Oh, there's only 10 schools in the top 10, as it turns out. So, but it is what it is. It's an oddity, I think, that would shock many people in the scientific world.
I mean, thinking about we're letting 2Ls pick our papers. So the metric maybe has to be the letterhead, because what differentiates one paper from another at the end of the day?
Now we're talking about publishing and all that sort of thing. I know in the legal world, legal academic world, you guys think in terms of, well, this was the article I just wrote and I've been working on and researching, and this is what I'm going to be writing about and researching moving forward. So, whichever one you want to talk about, but where is your research and focus at the moment?
I've been playing recently with ChatGPT, asking it not about articles, but asking it about me. Like, what is the through line of Kristen Osenga's scholarship? Which is fascinating because it has thoughts that I hadn't thought about myself. But then when you read it, you're just like, oh yeah, you're kind of right. So kind of the through line of a lot of my scholarship, both in the past what I have done, but also in the forward direction that I'm looking, is really what are we missing? What don't we understand? What are we getting wrong? Which coming from a place, you called me a unicorn, so I'm just going to run with it because that's actually very complimentary. So thank you. But coming from a place where I'm very pro property rights, pro patent, pro innovator, it feels like a lot of my scholarship is pointing out, hey, wait a second, all these other articles might be getting it wrong. Maybe we should think about this a different way. Maybe we shouldn't hate on patents. Maybe we shouldn't hate on innovators. Maybe we should think about strengthening things. And so, and that through line runs through both, like I said, what I've done and what I'm doing. So that's kind of the overall viewpoint. And I'm not using ChatGPT to write my articles. Just to be perfectly clear, I want to say that out loud. I'm only asking ChatGPT to tell me about how good my articles are. And it did that. And it told me I'm very practical and clear, and I come up with cute metaphors, and I have this through line where I'm challenging the status quo of IP scholarship. So cool. I'll take that. So where I'm at now, I have a couple of projects going on right now that are important to me. One's a very big data project, actually, where I'm looking at who is suing who. Because I think a lot of previous work that's been done in that space has been very targeted towards a certain question, which is patent trolls. We hate patent trolls. Patent trolls are bad. Let's look at the data to see how big a problem patent trolls are. I think there's a bigger story to tell there, right? And there was a paper quite getting quite old now, done by Colleen Chen, who, where she also kind of is like, well, maybe patent law is the sport of kings. It's big versus big. Maybe patent law is patent trolls. But even still, her paper at the end of the day really spends a lot of ink on patent trolls rather than all these other aspects. And I think that it's important for us to know who is suing who. Is it big versus big? Is it small suing big? Is it big suing small? Is it, it's not only based on whether or not the particular patent owner is a troll or not, because a lot of policy is being based on this, right? We are talking in the news about litigation funding. Well, litigation funding matters most when we have small suing big. Avenues to the ITC matter, not necessarily small versus big. Also, there's litigation funding at the ITC, but that's a different problem altogether. So, a lot of these policies where we're like, we need to fix this as a problem, starts from a position of we have a problem of big versus big, or we have a problem of small versus big, but we don't actually have any sense of how many cases are big versus big, or are big versus small, or anything of the sort. The only data that we have any sort of relevant numbers on is, are you a patent troll and how much are you suing? So I'm kind of trying to get a bigger picture without putting the patent troll judgment on it, because I think that's super important for policy. So that's one thing I'm looking at. Another thing I'm looking at is just my usual, we need to make patents stronger, and the system is weakening patents. I have a paper called The Erosion of Patent Enforcement, and it's kind of looking at all the different ways, kind of putting together an amalgam of all the different ways that over the last decade, patent enforcement has become incredibly difficult for innovators. Most often at the hands of, by golly, my academic friends who are saying we should take away jurisdiction at the ITC. Like, wait, what? Or we should continue the eBay. We should move eBay to Europe. Wait, what? Again, going back to my through line, there's a element of this paper which is kind of along the lines of, wait, what? All of these patent scholars are saying, let's weaken patent law, and I'm like, wait, no, let's strengthen patent law, and kind of pointing out the various aspects. And the last bit that's really captured my attention recently, and I've been talking about it, trying to situate a paper, is the intersection with standard essential patents. And I know you had asked me earlier, how in the world did you get into competition law? I started writing about standard development organizations, I don't know, maybe 10 years ago or so. I didn't start there, and I never practiced antitrust law. I did take antitrust in law school, but I took it from a professor who was so obsessed with Major League Baseball that that's all we covered. It's super weird. I learned absolutely nothing, but I know so much more about Major League Baseball. So I got interested because I'm like, these standard development organizations are churning out these patented things, and we have standard essential patents and they're being treated differently. And oh my goodness, what is going on here? And so I really kind of immersed myself in the standard development organization space and realized nobody knows what's going on. So I wrote some previous scholarship of like, what even happens at SDOs and why does it matter? And why are SEPs, why do standard essential patents matter? Why should we care? And what does FRAND mean? And so I've started working in that space. The nice thing about working in that space is it intersects very nicely with another thing that matters a lot to me, which is injunctive relief. So two pieces of my scholarship kind of coalesced into one space where I get to talk about why eBay is bad and why we need injunctions, while at the same time trying to clear up some misconceptions about standard essential patents. And so that's kind of been a nice place where a lot of my scholarship has just kind of come together recently that I'm writing about. And now with some of what's going on in the Department of Justice and FTC and how they're thinking about patents has actually become really hot now, and I'm super excited, and I really need to finish my grading and get on with my writing so I can turn out some more papers talking about these issues.
There's a lot there. One of the things that has always amazed me about the patent troll issue in particular, we don't have a working definition of what a patent troll actually is. I still think the definition of a patent troll, the best one, is the patent owner who's suing me is a patent troll. And it can't mean that. And so much of the most valuable innovation that we've had throughout my lifetime and before, and I'm sure moving forward from this point, comes from smaller players, individuals, startups, universities, that sort of thing. And they don't make a product. The product is the research and development and innovation. And if we want that to continue, then we need to reward that. And the way that we had historically done that is through the patent system. Let you patent it. If it winds up being valuable, you can either sell the patent or you can license the patent. And while innovation does continue to happen, even in the system that we have today, what doesn't happen anymore is the rinse repeat innovation. Because you would get this individual, the startup, the small business, the university, whoever it may be, on that level, taking great risks, dreaming big, comes up with something valuable. And now they have the opportunity to build a company themselves, maybe then sell the company or build the company and grow it to be a truly big company, which is what all of the Silicon Valley elite companies did. They were all small at one point in time. Or they invent something and then they can license it to others who have the ability to take it over the finish line because they own the channels of distribution. They can manufacture, they can do these things that are necessary. And with the interruption there, the innovator winds up not usually making money. They lose money in this whole proposition. And even if they do make a little bit of money, they're not making enough money to continue to the next iteration and the next iteration and so forth. And that has had to have dampened down innovation at large. And it just seems so painfully obvious to me that that's what's going on. And yet there are people out there who just continue to say, no, why don't we just take all patent owners out behind the woodshed and execute them? That would make for a better world. And then the last piece, and I'll shut up and give you an opportunity to comment on any of this, is I just, for the life of me, don't understand why people believe that the largest companies in the world, and not just the world, but the history of the world, these companies are so big, they're bigger than many countries. Their GDP is bigger than many countries. Why would anyone convince themselves that they have in their best interest, they're looking out for the best interest of the small player? No, that's just not what they do. But yet we live in this world where oh, Google says this, or Apple says that, or Samsung says this, or Cisco wants that. And well, they're the experts. They would know what's better for patents than anybody else. No, they know what's better for them. And I'll shut up for a minute and give you an opportunity to comment on this.
So patent trolls, I agree with you. Absolutely. And I think the unfortunate thing is, earlier when we got to the height of patent trolls and the narrative keeps coming up over and over again. But, there was a fevered pitch at some point, probably about 10 years ago, with patent trolls. And what was happening was like the nuisance suit idea. We're just going to send 50,000 letters to people who are probably infringing our really not super valid patent. And it had very little to do with who the patent owner was and very little to do with who was being sued and much more to do with the litigation behavior. Because even a manufacturing company could send 50,000 letters saying, "Stop infringing my patent, and I'll settle for a small amount just to get you out of my inbox." So I really think we missed an opportunity at that point when we were seeing a very small number of patent owners engaging in very vexatious behavior. If we had taken a moment at that time and said, "Wait, what is it about this that pisses us off? Oh, it's that you're doing this, like, on a grand scale with the hopes of just making nuisance money." If we had said it that at that time and that's what offends us, we may not have ended up in a position where we don't grant injunctions anymore to patent trolls, right? Because what bothers us is your litigation behavior, not the fact you make nothing, right? And so we missed the moment, and now we're stuck in, as you said, a place where, patent owners, or particularly patent owners that don't make anything, are almost viewed as problematic when it's not even in everybody's best interest to make anything.
Amen to you on the conduct is what should define the patent troll, because I think why though do you think, because I think you just accurately summarized what happened and when it happened and why we missed an opportunity. Why do you think that was? Why do you think, because you would have people who were not by any stretch of the imagination ever appropriately characterized as a patent troll saying things like defending, oh, well, we have to be able to have these bucket of rights associated with our patent. And it just seemed to me like they were defending the indefensible. No, shaking somebody down for $50,000, that can't be what we want out of the patent system. And yet there were so many people who were not that, but wouldn't throw that part of the industry, this very small part of the industry, but wouldn't throw them over the bus, or over the cliff rather. And odd things happen. Have you stopped and thought about why that was?
Well, I am cynical, and I think that goes to the second part of your question, which was what are these big companies and why do we think big companies should tell us how to run the patent system? I think big companies didn't like being sued by small companies. I mean, who likes being sued? Nobody. But these big companies saw an opportunity when the nuisance behavior was occurring to, instead of focus on the behavior like we just talked about, but to focus on the fact of we don't like being sued by somebody smaller than us. And how can we avoid that? Like we can categorize all of them as bad and make it much harder for them to enforce against us if we can somehow group even these incredibly innovative companies that are, by the way, coming up with technology that I, as Apple or Google, really want to use, which means it must be pretty good. Apple and Google really want to use that technology that's being developed by the guy in his garage who's never going to be able to manufacture anything. And they saw the opportunity to, jump in and make the claim, we are being shaken down by these people. And they focused on the these people rather than the shakedown. And I think that all comes back to money, because I'm cynical. I mean, they have the money to lobby, and they have the support of IP commentators, minus, the 5 or 6 of us IP academics that actually like patents.
I agree with that as well. The question, though, still don't get is like, why, for example, did the people in the biotech startup area or in the university research area or the folks that were standing up their companies and actually engaging in commerce, why did those people not say, hey, those patent trolls, you're right, they're bad. We need to do something to stop them. but then make the argument that's not me. My thought is there's two things. One is I think a lot of those people just thought it was self-evident and this would sort itself out. And they didn't want to draw attention to themselves is part two. So that because when somebody was drawing attention to themselves, then they became a lightning rod. And then you do get the mass weight of the PR machine and lobbying directed at you. And I think that that was a problem. But I do think the industry as a whole was fine. Patent owners are not a problem, but there are patent owners who can be problematic and bad behavior. But that like 1% of the industry or whatever it was, a very low number, just was never abandoned by the other 99% that was good acting. And I thought that was a mistake when it was going on. And now in retrospect, I think it was a gigantic missed opportunity.
I think you're right, and I think the piece that I would add to that, I think you're 100% right that a lot of those small companies in particular wouldn't stand up to be lightning rods, particularly given the PTAB at the time, 10 years ago, was a very different PTAB than it is today. But I also think, too, just to add another layer to it, is I don't think university tech transfer offices are oftentimes of the mindset to think about themselves as patent owners. I think they I don't know what they do, to be quite honest. I've read other people's papers, other scholars' papers on it, and it seems like with few exceptions, and there's definitely some exceptions, but with few exceptions, tech transfer offices really are just set up to gather information, gather invention reports and send them out. They're not really engaged in the policy, engaged in the patent law aspects of it. They're more kind of a invention disclosure recipients. And so I think that's another place where they just didn't have the wherewithal to stand up at the time when it could have been useful to point out, oh, wait, hey, there's another kind of patent owner here. I just don't think they had that capability.
That's probably true. And I think that does feed into some of my thoughts on the topic in terms of they were in some respects so busy doing what they were doing, they didn't see the bigger picture about what was happening. It wasn't their lane. They didn't need to come to this defense or that argument. And then sooner or later, when you don't stand up, then the target shifts and it becomes on you. And then little by little, it started taking on this life of its own. And it's been very unfortunate. I also think a big problem that we have, and this is also a problem in the SEP space, I think, I'd like to get your thoughts on this too. The other side, the implementer side, is much easier to articulate, and it seems to fit much closer with the common person's understanding, although that's not true. Like, for example, I'm so sick of hearing patents are monopolies. They are just not monopolies. And if they are, they're the least efficient monopoly ever envisioned. Because if I patent something and then don't continue to push the ball forward, you can patent the next version and then block me from my own pathway. And the other thing too is 98+% of patents don't make any money. You get them with great hopes, but only about 2% of inventions wind up making money. So 98% of these patents protect no market activity. And if there's no market, there can't possibly be a monopoly. I mean, there's just two reasons. There's any number of reasons why patents are not an economic monopoly, but the Supreme Court has said they are. It's so easy to be, oh yeah, exclusive right, that means monopoly, and monopolies are bad, therefore I hate patents. And it's like, oh my God, you cascade from one bad fallacy to the next. And what do you say about that? How do you deal with that part of this whole debate?
That is a good question, and that's why I write papers, to try to handle that side of the debate. But but you're right. I think the implementer side of the SEP debate oftentimes looks good to the consumer. So it has the court of public opinion is on the side of the implementer, because the arguments that oftentimes the implementers are making is the patent owners are charging us too much money. It's making your products too expensive, right? And I mean, that's the argument, right? And it's
Mhm.
like, if we have to pay, they call it royalty stacking. If I have to pay royalties to this company and this company and this company and this company, our phones are going to have to be 40 gajillion dollars. Well, funny, our telephones continue to, are they even called telephones anymore? Smartphones? I don't know. I'm old. Our phones are continuing to improve in technology, constantly improving in technology. The cameras are amazing. The service is great, even out in the middle of nowhere. Like everything about our phones is better than it was. And the price increase is not commensurate with how much better our phones are. In fact, sometimes phones are cheaper than they used to be under, moderated dollar amounts based on inflation, whatever. I don't know how to do math with money. But the idea that implementers are trying to sell to the people are, your phones would be so much cheaper if we could just break these patents. No, your phones wouldn't have cool technology if we broke these patents. And that's not the sale that they're making. So I think you're right. It's just that the implementers are telling a good story that people want to hear, and judges weirdly are people and they want to hear it, and they don't understand patents. The public doesn't understand patents. Judges don't understand patents. So I think you're right that the implementer has an easier story to tell here.
And they're not challenged because even if you weren't considering that, well, these patents protect the technology, so you like the technology, you just don't like paying for it, is what it really boils down to. The statement that your phones would be cheaper but for the patents is just wrong. It's not true. It's a lie. And because at least fundamentally, I think most people would believe it to be a lie because the royalty stack for a smartphone is like $12 to $15 on a product that's $1,200 to $1,500 that is so expensive anymore, you don't actually buy it. You buy it over time. You pay it over time like you're buying a car. I remember when you used to buy them upfront at Verizon or AT&T or whatever, and you don't do that anymore. I mean, so what you're spending on a 3-year plan if it's just say $12 so that, the math is easier, right? Or $15 stack so the math is easier. I mean, you're paying $5 um a year. I mean, you're not even paying $1 a month for the technology that's powering the phone. I mean, it's laughable, And the other thing, like in the standard area too, with the automobiles are essentially now a rolling computer, and you have all those kinds of computer devices and displays and sound systems and video systems, and that requires connectivity, and that's where a lot of standards live. They were charging on the order of $30 to $40 for a vehicle that today now, I mean, you can't buy anything other than like the lowest end of the lowest end for $30 or $40,000. I mean, so $30 or $40 for a low end vehicle that's $30 to $40,000. At a high end, that's could go as high as, just absurd prices. But I drive a Ford F-150, and I'm always constantly like looking and dreaming about my next Ford F-150. And they're going now for in the order of $50 to $100,000, depending upon what you want. And you could get a little lower than 50 if you want like a bare bones construction type utility vehicle. But for most people who are going to drive it every day, you're going to pay between $55,000 and $80,000, maybe $85,000. And you're telling me 30 or 40 bucks is too much for a backup camera and some video technology in the backseat for my kids or grandkids? I mean, it's absurd. It's just absurd.
Yeah, yeah. I mean, it does evidence like the story isn't based on facts, and the people. That's what the people want to hear, right? The people want to hear, oh, but it would be cheaper if, because phones are expensive, cars are expensive. And so if you tell them, well, it would be cheaper if, it's a plausible story until you hear it's $15 or it's $30, right? But you don't think about it that way. And you can be sure the implementers aren't telling that story, right? They're telling you that your phone is $800 to $1,200 and it's because 6G, right? And that's the story. And the average person on the street is going to believe it because they don't understand patents.
It's frustrating, and I think it's just that simple. They don't understand patents, but it fits their preconceived notion. I'll give you for instance, in the standard area. I wrote an article a couple weeks ago about standard essential patents, and I didn't want to have to rewrite a paragraph I've written, I don't know how many times, about how it is possible technically that the implementer is not infringing the patent, even though it is a standard essential patent when the implementer is adopted the standard. And it's all based on the fact that standard essential patents are standard essential because the innovator disclosed them to a body who then considered all of the various technology and said, okay, this is what we're going to say is the standard. So the fact that the standard doesn't quote unquote actually cover your patented technology does not mean your technology is not standard essential. It also doesn't mean that you didn't give any value. You put all your stuff on the table so people could see in advance what they picked. And sometimes I think what they'll do is they'll steer away from certain people that they don't want to loop that technology into the standard, right? And so there's value here. So I asked ChatGPT, just write me a paragraph, just a simple paragraph that explains this. And it got it wrong. It said, "Oh, no, you're mistaken, Gene. If it really is standard essential, you can't practice the standard without violating the patents." And I'm like, oh my God. So then I had to write the paragraph anyway. Only it was way longer than the paragraph because I had to teach ChatGPT what it really was right. And it's frustrating, but I tell that story because the problem that we have is the information that's out there about patents is right to 99% of the public that just needs to be in the ballpark. Maybe not even in the same ballpark, but like the same county. As long as you get close, that's all they need to know. But for policymakers and judges and other people in our industry, getting close is not enough. You got to get it right because there are important nuances here. And I struggle to get people to understand that. I suspect you do as well. And that's why I've referred to this sometimes as it feels like I'm just shoveling water back into the ocean. Now, in your existence, I imagine it's even worse because you are literally one of the 4 or 5 people in the world that is both an academic and believes patents matter. How do you cope with that? How do you get your point across? Because you keep trying to do it. And I mean, for me, I think you're effective, but it's got to do you wake yourself up every morning and give yourself a pep talk that today is going to be better? Today's the day we break through.
I mean, yes, but I would do that anyway. But no, I think a couple of things. I think first, cynically, it has kept me able to continue writing. I mean, if all of a sudden the world started understanding what patents were and started believing what I believe, I wouldn't have much to say anymore academically, and that would be really sad. I'd have to come up with a new line of scholarship. But I think more truthfully, it's been good to just keep saying the same thing. I tell my students when I have them, and then my students go into the world and they have at least some semblance of understanding. And I write the articles and, maybe the 5 people that read my articles, now they've walked away with some semblance of understanding. I think it's a little like shoveling water back into the ocean, but I think occasionally something lands and makes a difference. And that's what I have to keep telling myself. I think it's most effective probably with my students. And they go out into the world, and maybe they aren't patent policymakers, although some end up close to that kind of work, but at least they end up in the world with the idea, and I think the more people who have the right idea, they can continue to spread it to other people around them. That's the way I have to kinda go through life, because otherwise what would be the point?
I hear all kinds of craziness though, and I'm sure you do as well. Recently I heard again, and this is not new, it's not unique. It happens. A lot of people hold these beliefs like innovators innovate. That's just what they do. It doesn't matter whether they get patents. It doesn't matter whether they have exclusive rights. And it doesn't matter whether we're talking about pharmaceutical or not, where it takes billions of dollars to get an innovation to market. If they don't have exclusive rights and there's a generics immediately, well, the innovators, what are they going to do? They're going to innovate anyway. And I'm like, I asked this. So your position is that they're going to spend billions of dollars to get a drug to market where the generic can immediately undercut them by 90%. And even if that were to be true, you just put that company out of business because nobody can spend billions of dollars and make millions of dollars and have that go on any length of time. And I was told by this person the other day that, well, yes, that's the way it works. They're just going to keep inventing. I'm like, they're going to go out of business. And I have to think that smart people fundamentally understand that. But I don't know. I mean, there's a lot of smart people that seem to have this belief that pharmaceuticals in particular, or AI, which takes billions of dollars to take some of these platforms across the finish line, they don't need protection. And to me, it's like, are you kidding me?
So I tell my students this, and I also am starting to incorporate it more in my scholarship. But and maybe when you're 22, this is excusable, but it's probably not excusable when you're a grown up staffer or politician or whatever. But companies are in business to make money. Period. Full stop. And I say that at the beginning of at the beginning of patent law. I'm like, okay, we're going to start from this premise, y'all. I say at the beginning of antitrust. I even do it in my 1L classes. I'm like, okay, we're going to start from this premise. Companies are in business to make money. And I think that actually that's a piece that I don't know how a lot of policymakers or commentators miss. Like you said, the person you're talking to, same sort of thing that's come up recently that with respect to standard essential patents, not just pharmaceuticals, but the idea of royalty-free licensing. Every time I talk about that idea of royalty-free licensing, I'm like, okay, but follow the money. There's got to be money here somewhere. What is the money here doing? Is it really free? Because companies are in business to make money. We got to remember that. We got to start from there always. Companies are in business to make money. So what is royalty-free licensing getting us or them? So I think that's one of the things that I've really started to implement in the way I think about patent policy and competition policy is where is the money? Who's making money from this?
Yeah, that's just an evil word. I think I have a friend, he likes to say, is it free as in beer, free beer, or is it free as in free puppies? Because one of those two things is not actually free. And I'm a dog person. We have 6 dogs. We love dogs, but a free dog is not cost neutral. And you get an awful lot of good out of the dog, and they love you to death and all that sort of thing. But it is different than free beer, where somebody's just handing out a beer and you consume it and say, "Hey, thanks, pal. I appreciate that." But people just want free. They want free, free, free. And I think that they're just predisposed to take these arguments that, oh, it'll cost less if only patents didn't exist. And just they want to believe it. And if you're trying to tell somebody something is untrue that they want to believe, they're immediately on the defensive. And then you just almost can't make any point.
That's a fair point. At least starting from the premise that companies are in business to make money should get us a long way through some of these policy discussions in ways that it currently isn't.
Thank you for listening to IP Watchdog Unleashed. We will be back next week, and we hope you will join us again. In the meantime, please be sure to visit IPWatchdog.com to read all the latest news and information about what is happening in the intellectual property world. And also be sure to subscribe to our free daily email newsletter.